Good day. I am here today to talk to you about mediation and the importance of mediation in trial work. In the modern day, more than any other time, your case that you file in court is most likely to settle. And now that might not seem, to make sense on its face, the reality is that litigation is fraught with peril, if you will. In other words, you could have a judge that grants summary judgment. You could have a situation where a witness does or says something, whether in deposition or at trial, that makes you think it might be better to resolve this matter. So what we like to say when we teach in trial work is, it's like going to Vegas and rolling the dice, because you don't know what your jurors are thinking. You don't know what your judge is thinking. And even though you're putting on your best case, a case that you may have, shopped in front of a focus group, you still don't know what that outcome is going to be. So the facts that have sounded so great to you at your firm all year may not sound as great when you have to open them up and let them be seen in a courtroom. Everyone wins, right? Everyone's interests are met when there is a resolution of the claim short of trial. Now, nobody's going to be ecstatically happy. You're not going to get the greatest verdict that you would have gotten if you had taken it to trial and won. Or if you're a defendant and you have the potential to lose millions and millions of dollars, yes, you have the opportunity to not lose any money, but the question becomes, you may not get this perfect result, but you get a result that you can live with. And most people are risk averse, and most of the time no one has a perfect case. And I can tell you, after decades of litigation, that no one has a perfect case. And even the case that appears perfect can deteriorate, it can go left, somebody can ask the right question and you can get the wrong answer for your side. And so alternate dispute resolution, which is the umbrella for all types of early resolution of a case, is very big, and there are no courts. I can pretty much say, it's rare that a lawyer can say that, but there are no places where early resolution of the case is not welcome. And there's all different types of early resolution. There's something called early neutral evaluation, right? If it's a routine case, sometimes you can have a neutral who evaluates the case on the front end and says to the parties, hey, before you spend money on this case, go ahead and get together and try to resolve it, because we know what these cases are worth. We understand what these cases do in front of a jury. Rather than spend all that time and effort on an outcome that is pretty much known, why don't we go ahead and try to resolve this early? Another form, and this works, I think, in a more a simple case, right? Fender bender, things where it's pretty routine. But if you're doing a complex piece of civil litigation like you do in our classes, then you will need to use a higher level of mediation. And in this case, we are going to do a mediation. And a mediation is where you have a neutral come and listen to both sides of the story. Now, this is a time when you're mostly focused on the facts, but of course your neutral, your mediator, will know the law, will understand the law, which is why they're your mediator. And sometimes it's a judge, sometimes it's a very senior attorney, but usually your neutral will understand the law as it applies to your case. So you'll come, you'll explain your side of the case, they'll explain their side of the case, and then the neutral will typically break you up, right? They'll talk to you one side at a time, and they will try to get a real understanding of what you think is the strength and the weakness of your case. and what you think the true value is, right? And the reason why we do that and why we do that separately is obviously in front of the other side, even though it's confidential and everyone who comes to the mediation must sign a confidentiality agreement, whether it's your client or whether it's the insurance adjuster or whether it's any other person in the mediation. The reality is, if this doesn't work out, you are going to trial. So you don't want to share the secrets that will come out in the trial, although there are very few secrets in a civil proceeding, but certainly things that are strategic, right, that are going to be sort of your banner. You don't want to reveal those until you get to trial. So mostly what you'll find is that mediators will break you up side by side. I like to have an initial proceeding where people come in and describe their case in front of the other side. This is very important, and I want you to listen to me very carefully. When you come to a mediation, most mediators, I'm not saying all of them, but most of them will ask you to do a non-argumentative version of your side of the story. Now, that doesn't mean you're not advocating. It's almost like a mini opening. And if you get this right, the other side will leave that room thinking, you know, maybe my case isn't worth as much as I thought. Or if you're the other side, you'll be thinking, maybe we need to pay a little more than we thought we would pay. And I can tell you from personal experience that if you get this mini opening right, you tell a story that's cohesive with your facts. You don't embellish. You don't make up facts, because you'll be caught, and it will not help your credibility. But if you do a really good opening statement of your story of the case, you can influence people who need to be influenced, whether it's the lawyer for the other side, whether it's the insurance adjuster, who is as powerful as anyone at a mediation because they're the ones who come with the money. And if you can convince them that this isn't going to look good in front of a jury, and that the insurance company could be on the hook for a lot more money than they would have to pay today, you have done the most amazing thing you can do as a lawyer. You have convinced the real person who has your interests able to be met. You've convinced that person to turn over to you the thing that will allow your client to go on or allow your client to avoid a trial. And trial is very hard for people. I think that, you know, when we do this for a living, you're practicing trial advocacy, you're practicing pretrial advocacy motions. So for you, this is the business of what you do. But imagine if you're a real person and you have to be prepped for hours at a time, and you have to have your family prepped, or you have to have your coworkers prepped, and it takes hours and days, and your lawyers are spending money. Whatever side you're on, your lawyers are continuously spending money. Trials are very, very expensive. When you have experts and they have to come to trial, they are charging you either by the day or half day, or they are charging you by the hour, and they like to use the word portal to portal. And that term means from the time they leave where they come from, and if that's LA, or if it's San Francisco or New York or Boston, you are paying from the time they leave the portal of where they come from to the time they return to that portal. And as you can imagine, they're not charging $50 an hour. They can be charging hundreds, sometimes thousands of dollars an hour based on their expertise. And so as you can see, the costs start to wrap up really, really rapidly. So it's very, very important that you weigh the cost of a trial and the benefit of having a mediation. So let's talk about the other option that you have if you don't have your case mediated. There are cases that are arbitrated. Arbitration is where you have some third-party neutral come in, evaluate the facts, and make a final decision. That is, in other words, it's a substitute for the judicial process. This person then writes an opinion, and their opinion is agreed to by the parties to be the final resolution of the case. Most people in the civil setting don't choose mediation, because if they don't like the result, they like to be able to go back to the judge. And the thing about mediation is it's very much a meeting of the minds of the parties. And so it's a result that they choose. Sometimes you'll have mentors and they'll say, you know, you would much rather have the result that you chose and not necessarily the result that a judge or some other person, like an arbitrator, chose for you, because you can usually craft a solution that works better for you than someone else. So let's talk about what we're going to do in terms of the class, okay? In terms of class, what we're going to do is we're going to actually simulate the mediation. And as you've seen throughout our time in class, when you're taking depositions, when you're arguing motions, when you're filing pleadings, you are putting together your case, okay? So you're putting together your case for a resolution in front of a judge, in front of a jury, and that requires a specific set of skills, right? Your written advocacy skills, your oral advocacy skills. Well, mediation requires yet another tool in your toolbox. This is why people who try cases, you know, are sort of, you know, Jack and Jills of all trade, because they have to be able to file the pleadings, they have to be able to argue the motions, they have to be able to interrogate witnesses at deposition, interrogate them when they're sitting on at the witness stand, but they also have to know how to mediate their case effectively, and they have to be have the balance of advocating, as I said in the opening statement, and learning to negotiate, right? What am I willing to give up to get something that I really need? So when you think about who's going to mediate your case, right? Sometimes in a firm, some people are really good at negotiation. You know, it tends to be people who are able to listen, right? Because a lot of what mediation is listening, right? When you hear that opening by either side at the beginning, you should be thinking to yourself, what is really important to them? What do they want to get out of this? Sometimes it's not just money. I realize that in civil cases, that is the number one thing that you can get, but there may be other things that are important to someone that would make them give up money. And those things include things like, you know, making sure that whatever happened in this situation doesn't happen again, or that there are policies in place to make sure that this doesn't happen again. Maybe this person wants specific remediation. Sometimes people will want an apology. It's very rare that you get those, but sometimes people want an apology. And I will tell you that I have seen clients who, in the face of an apology, will accept a different financial result than they would have if the apology had not been provided. I mean, classic wisdom, you know, when you're litigating against someone, is that people don't apologize, right? The litigation process decides who was right and who was wrong. But when you're dealing with human emotion and you're dealing in mediation, alternative methods to resolve an issue are what you're looking for, right? These are the kinds of things we'll be looking for as we watch your mediation, is whether or not you're being creative about a solution that touches the situation that occurred and that leaves the parties in a better place than they began. So it's very, very important that you be creative and that you listen, because usually people will give you clues in how they say what they say at the mediation to let you know what they're really interested in, or even how much money it will take to resolve that issue. So keep that in mind, because it's going to be very important. So let me paint out for you what the mechanics are of the mediation, right? These are the things that you can't just get from a textbook. So before the mediation. Typically, before the mediation, the parties, both parties, right, the people who are the plaintiffs and the people who are the defendants, they will file with the mediator and only with the mediator. I'm going to say that again. You will file with the mediator and only with the mediator a confidential settlement statement. And the reason for that is it's confidential. You're going to say things in this statement that you would not say directly to the other side. And the reason why you're telling the third party mediator is so that they can review the case from your perspective and hear what your theories are and hear what your proposed result is and understand, whether there's insurance and what funds are available, and certainly for the plaintiffs, understand what they're looking for, what specific damages they're claiming, information about how they'll prove that, and certainly at the end, you'll expect people to tell you where they think the case would settle. So this is really important, right? Because the mediator is reviewing this document before you ever step foot in the mediation. So this document is very important. It is not a legal brief. If you find yourself writing a brief and citing cases in your confidential settlement statement, you are not on the right track. Because if you are just arguing the law to your mediator, you're probably not going to be persuasive that you have a great case. What you need to be arguing, again, if there's some specific case on point, I'm not saying that, not to include that. I'm not saying if there's some failure of proof that you not cite a case and say, look, if you don't have causation, you never get to damages. You can make that point, but you also have to make the point about why you win based on your facts. And you'll see as I talk about this why this is important, because both sides are doing it. So the confidential settlement statement is an opportunity for you to factually based, right, truthfully. You don't want to say something that the other side is gonna, if the mediator throws it out with your permission to the other side goes, well, that's not true. Here's a deposition of blah blah blah, and they say this didn't happen. So you don't want to. This is not a time to argue. This is a time to lay out your facts in the best way possible, lay out your damages, lay out what you want for the case in a way that has advocacy behind it, a way that is convincing, a way that is honest, and in a way that will help the mediator to understand why this is so important to your client. So if you're writing something that sounds like a brief, no. If you're writing something that is simply, what you hope to show and not what you can actually show, that's probably not a good idea. A good mediation confidential settlement statement includes a statement of the facts so that it's in the light most favorable to you, but certainly in the light that you can prove. And so the confidential settlement statement will be a form. We give it to you as a template. A lot of courts have their own template. This is the template that they use in the District of Columbia. And this template has the caption of the case. It'll explain what the case number is. It'll say that it's scheduled for a mediation conference, and that mediation conference is scheduled for this date and time. And then it'll say what kind of case is it and what side was it submitted by, and each party will submit, even though you might be on the same side, you still will submit a separate mediation statement. And then the first thing is the nature of the case, right? You want to make sure people know it's a contract case. It was an accident. It's a sexual harassment case. You want to state that up front so that people know what kind of case it is. And then you will describe from your perspective, whichever party that you are, you will describe why you believe that this case is favorable to your client. Okay, so even though it's a form, it's not like fill in the blank, how few words can you use? It's how many words you need to give a convincing statement of why this case will result in your favor. Then after you do that, you describe the relief that you're requested. And in this setting, it will ask you to describe any monetary relief. It'll ask you to briefly describe, any other type of relief that's being requested. It will also ask you to describe where the discovery process is. Why is this important? Mediators typically mediate big, complex civil litigation after all of the discovery is done, and sometimes after the dispositive motions. Now, I will tell you strategically, there are times when lawyers like to do it before dispositive motions have been decided, and the reason for that is if you think that you might lose a claim or the actual case on a dispositive motion, then you have a lot of incentive to try to work it out before a judge does that. And sometimes the judge will say, well, guys, you can let me decide this, but I'm recommending that you all go to mediation and resolve that. That is the signal from the judge that, you aren't going to like what I do. So you better go off and do something that you both can live with. So, keep that in mind. That's why when I talk about listening, that's the kind of thing you want to listen to, because if the judge is signaling to you that not good things are going to happen when this is reviewed, and they lean down from the bench and they say, go out there and get this resolved, then you know that the judge is telling you that this isn't going to go well, and you don't know whether it's not going to go well for you or for them, but just the ominous sound of it lets you know that a result that you create for yourselves will always be better than a result that people create for you. And we always like to say, if you leave mediation and you are ecstatically happy, somebody didn't learn these techniques in law school and they gave you a result that's better than you probably could have gotten at a trial. But usually, most people leave mediation feeling like they didn't get something they wanted, but they got enough of what they wanted that they were able to resolve the case. So keep that in mind, because that is really important to how litigation and mediation will proceed. Additionally, the form will also ask you to describe whether there are any pending motions, and so we talked about that. A lot of times it can be strategery, right? A way of kind of having that motion out there as sort of a stick to get people to resolve the case. And then it will also ask whether or not there are liability issues in dispute, okay? So it's very unusual not to have liability issues in dispute, but it can happen. I won't say that it can never happen, because it does happen that liability might not be in dispute, but there might be some other aspect like causation or the amount of damages that causes people to say, oh yeah, we'll say, if we were liable, if somebody's liable, it would be us, but they can't prove causation, or they can't prove any damages as a result of what we did. So, there's always something that has to be proved, and you have to keep that in mind. So, at the end of the confidential settlement statement, it will ask you questions about insurance, right? Do you have insurance? Does it cover these claims? Do you have excess insurance? A lot of times people have excess insurance. So there are going to be all these questions about what fund of money is available to resolve this claim, in addition to, right, whatever monetary amounts or whatever other ways there are to satisfy the judgment. And obviously in a mediation, people are looking for, money that is sort of free and clear. You don't want to have to sell your building, but there are cases where that's exactly what people do. So this is an opportunity for the mediator to understand what pools of money are out there to resolve the claim. So you will actually provide that to the mediator. And then the mediator will ask both parties, because it's on the form, they will ask, has your position been conveyed to the other side? Now, what I'm talking about right now is an initial, it's called a demand, but usually more and more, they're not styled as a demand. They're called demand letters. But you don't actually say, I demand you give me $1 million, because as one very famous lawyer used to say, well, what happens if you demand $1 million and they say no? What do you do then? So the object is to convey your settlement position, right? It's a demand letter, but it conveys your settlement position to the other side. So typically, right, best practice, the plaintiff is the person who sues. The plaintiff is the person who files the lawsuit. And therefore, even if you think about negotiation principles, it's still okay that the plaintiff send the letter in advance, preferably of the mediation, to the other side to say, my client, right, will accept the sum or the activity or the set of activities and money. My client will accept X in full and final settlement of all of the claims in this lawsuit, right? Plaintiff has to take the time to do that because they kick the ball off, right? It's rare, but it does happen that the defense will say, look, so-and-so, plaintiff, we will resolve this matter with you for X. I can tell you that typically if a defendant does that, it's usually for less than you might have been able to get. So it's usually a starting point. And I think most people recognize that whatever that is, unless people use magic words like, this is all I'm ever going to give you ever, I'm never going to give you any more money unless you win it at trial, then pretty much it's a starting offer. And this is why we start to talk about negotiation, right? Everyone will perceive, right, the first letter or the first notion of what you want to settle the case at as a place where you begin. Therefore, you must begin at a place that you can come to another place, which is what the money is that you would actually accept. All right, let's say that like one more time so that we're all in the same place. If I ask for $5 million to settle my claim, it is likely, and I can tell you for a fact in my experience, almost always, I'm not expecting to get $5 million. I already have another number that I would like to have and that I have pitched to my client as the number that I would accept. And if by some chance that number needs to be adjusted, I have my client right there and available, and I have them sign in writing as to what the number is or what number they will accept, or a changing number or zone of numbers they will accept. Why? Because this is the kind of thing where you have to be clear with your client. And in the heat of negotiation where numbers are flying, you want to make sure that if your client moves from $5 million to $1.5 million at the end, that you can show a progression, you can show that you've asked, you can show that they've signed off on your making this other offer. And this is very important because if at some point, you know, let's say your client says, I accept $1.5 million, you tell the other side they're willing to pay $1.5 million, you don't have anything in writing, your client goes home and they talk to you fill in the blank, father, mother, sister, brother, cousin, and they're like, that's all you got? That lawyer didn't give you, you know what? You deserve $10 million. Okay, if you don't have this in writing, you are in a very bad place. And if you have to go before a judge, and actually the confidential mediator will say this, you know, you have agreed to fully final settle for this. Usually the mediator will make you sign for it right there, then and there. Then your client is going to basically, if they try to undo this deal, they're going to have to do it before the judge. And if you don't have any backup documentation and you're not able to show this progression, then, you know, it's possible that the client could blow up the settlement. You could go to trial. You could lose. And so now the client's looking at you like, what happened to my $1.5 million? But they only have one case. You have cases all the time. So best practice is whatever amount you put in writing to another side, I don't care whether you're the plaintiff or you're the defendant, have someone sign off. If it's the initial offer, Have them sign off and say, I realize that this number is higher than any number I could get at the end, but I understand that to start the negotiation, I need to have a number. I'm comfortable with this number. I accept and I authorize my attorneys to share this number with the other side. That's good practice. You will find when you get to firms that lawyers routinely confirm things in writing, and this is definitely one of those places where you want to confirm the numbers with your client in writing. That's a lot of the reason why clients are required. People with settlement authorization are required to come to mediations, right? Because if it's just the two lawyers there and the lawyer says, well, my client's not here and, they can't, I can't agree to this, what you will find is that the mediation will be stalled. And so in order to make the mediation effective, most courts will order that the plaintiffs and defendants come to the mediation in person, or the person who has the settlement authority, if it's an entity like a corporation, but some human being must be there who is capable of agreeing to a full and final settlement. So that's why it's important in the next session that you list out every damage that you can prove. And that's going to include the nature and extent of a non-economic loss, right? Like pain and suffering, that's non-economic loss, right? An economic loss is something that is capable of putting a precise value on it. And then if you're saying there's a permanent injury, you have to state the basis, right? Do you have a doctor saying, she's permanently blind, or she's permanently unable to work in certain kinds of positions? Again, you need to be able to lay this out. If there's any future care that your client's going to need, right? Is there going to be a future surgery? Is there going to be future medical care? You have to lay that out. You have to lay out the number that's associated with the expenses to date, which is, right up until the mediation. You'll want to know what the future medical expenses are, the loss of earnings, the loss of future earnings. You'll want to know if there's any special damages or any general damages. You want to know if there's a loss of household services, and you'll want to know if there's any punitive damage that are alleged. So that's really, really important. The mediator will have in the form, they may want you to identify the expert witnesses. Certainly that's something we will do here, because the mediators, will want to know, how are you going to prove these damages? How are you going to prove your case? And so that means you'll need to have the expert witnesses listed and their areas. And then the mediation statement will ask, is there anyone else who needs to be at this mediation other than the parties? And sometimes the defense or a company will indicate that they need to have their insurance adjuster, or they have to have, somebody from their excess insurance coverage there, because those people also are decision makers and whether they're going to cover certain things under the policy. Okay. And then, of course, most important, the mediator needs to know if plaintiff has tendered a demand to the other side, then basically the mediation begins after you do your opening statements with a sit-down talk with the defense if they have not countered the initial offer. If they have, then the mediator will start back at the plaintiff. Or if the plaintiff hasn't tendered a demand to the other side, then you would start with the plaintiff. But again, good form is that the plaintiff should tender. If I know I'm having a mediation on my checklist of things to do, number one with a bullet, have I made a demand to the other side? Because now they can be talking about my number. They know what my number is. They can plan for my number. They can decide whether that number is outrageous. They can decide whether that number is reasonable. But they can come to my mediation prepared, because if they don't come prepared, that makes it take longer. And just so you know, just like trial, mediation, if you have a private mediator, and most big cases settle as a result of having their own personal private mediator. But as you might imagine, that costs money too. And a private mediator can cost you anywhere from, in today's dollars in 2017, it can cost you anywhere from, you know, $300 an hour to, you know, $1,500 an hour or $2,000 an hour, depending on the stature of the person who's doing your mediation. So if you have, you know, a federal judge who's doing your mediation, usually a retired federal judge, not a sitting federal judge, they can't charge that. But if you have a retired federal judge, they can charge you the value of having their expertise at the table. And typically, private mediators are either retired judges, or they can be, you know, really, really high-end lawyers who do these cases, who know what it looks like in front of a jury, who've tried these cases, and who are able to share that expertise with you in helping you to resolve your case. And I think it's the respect surrounding what they've done in their careers that really is what you're paying for, to have that advice to help you move through a mediation. And usually, if this is what they do and they practice it, you know, they are very skilled. They can get you to a number that you will agree on. Again, the question is, you know, how much time will it take? Sometimes if it's a bigger case, it can take more than a day. I can tell you that our mediation in class is timed, so we will try to resolve it within that time. And that's what will drive how we'll proceed. But if the plaintiff has made a demand, then usually we're in a good posture to be able to resolve the case within class time. So that's very important as you think about getting ready for the mediation. Okay, so now you filled out the confidential settlement statement for your side. I'm repeating this, I know I'm repeating this, but I'm repeating this because it's important. And, you know, from time to time, people make the mistake of filing their confidential settlement statement, trying to file it at court, although court typically won't accept those. You must only send it to the mediator. If you're on the defense side, you can decide whether you want to share it with each other, but certainly if you're plaintiff, you do not share it with anyone on the defense. And if you're on the defense, you do not share it with plaintiff unless you want them to know how much money you're willing to spend up front. And if that's a lot of money, then you've given away more money probably than you may have needed to. And if you're the plaintiff, then now you've told your whole theory of the case and how much money you truly want, and now it's in the hands of someone who does not have you winning at heart. So you want to send it to the neutral. That's why they call the mediators neutrals, right? Because if you send it to the neutral is not going to be able to share it with the other side. They're not going to be able to, you know, hint to it to the other side. And a really good mediator does not say anything to the other side that you have not sanctioned or authorized, right? If I want to let them know that their theory is weak and I can, you know, I will be able to attack it successfully, I may choose to tell the mediator that, but I may not choose to let them share it with the other side. I may choose. It's again, all of this is about strategy, and I say strategery to say strategy in action, right? Because everything you do is about moving your client to a resolution of the case. And let me offer you this. Sometimes in mediation, you may know that the parties aren't going to get to the precise number that day. But your goal should always be to get the number closer to where you want it. So if that's lower, it's lower. If it's higher, it's higher. Because when you start to negotiate again, you will almost always start from where you left off. And from where you left off is better than starting at high and low again. Now, there are times when some bad thing happens and then you may have to reset those numbers. But typically, if nothing intervening occurs, if you stop a mediation and then, you know, just before trial when people are much more highly motivated to settle, because again, it really needs you to be thinking about what all of this looks like. Trial preparation, depending on the size of the case, can take months, it can take weeks, it can take days. But I assure you that every day until the day you are in trial, you will be working all day, because there's always something that has to be done. And so it's not like you can prepare for a trial a year in advance and just be ready. You always have to prepare. I've retried cases, and you have to prepare all over again as if it's the case the first time. And so that's why just before trial, everybody has more incentive, right? Most cases, if they don't settle at mediation, they usually settle just before trial, because just before trial is when people realize that they're going to spend thousands of hours getting ready to go before that jury, depending on the size of the case, and hundreds if it's even a smaller case. You literally work. I remember once a client said to me, I didn't know that lawyers worked on Sundays. And I was like, lawyers work on every day that they have before the trial, because that's a day of trial preparation. So when you have all that in mind, you understand that each day is an opportunity for you to be getting ready for trial, okay? So now I want to tell you these last tips that I think will really help you as you prepare for mediation. The first one, have a plan. Do not go in there with that one number that you have and expect for that number to survive till the end. Already know where you're planning to go and how you're planning to get there, what your strategy is to move the other side to the number that you want. That works for either side, right? If you don't have a plan when you go in, I remember, having to plot out, if they do this, then I'll do that. If they go up this much, I'll go down this much. I mean, you really have to be thinking, where am I trying to get? And everything you do has to be strategically related to that. Now, you will, there'll be some give and take, but again, if you ask for 5, you're not likely to get 5. So the question becomes, where are you going, and what do your facts say, right? It's not just, I asked for 5, they got to give me 4. You've got to be able to demonstrate why it makes sense to pay that money, or why it makes sense not to pay that money. You see what I'm saying? And that's not just negotiation, that's strategy, because people don't just pay money. People don't just, ask for, you can't just ask for lots of money, because the goal is that this is compensatory for an injury or for damages that can be proven. So you have to be, whenever you're saying, well, look, we've lost household services, or, they can't prove X, Y, and Z. So there's no money that goes with that. So you've got to always, every time you talk, you have to be talking from the perspective of, I can prove it, the jury will see it, this is bad, it's going to cost them a lot of money, or they haven't proved it, nobody even talked about this is what happened. We think that a jury will find in our favor, whatever side that is. Okay, so you definitely have to have a plan. And then once you do that, you also have to be thinking, how do I demonstrate objectively the value of my case? So this is my favorite tip. Westlaw has a database that's called JV-All, JV-All, and what it is jury verdicts. Now, it won't always work for every case, but for certain types of cases, Westlaw has compiled the jury verdicts in those cases. So, if you can show that in a similar case, they got X or didn't get X, that might be helpful to persuading someone. I will tell you that the more you litigate, the more you will already know what it would look like at jury. The more you litigate, the more cases you have, you'll have your own cases. Well, Your Honor, in the case of Doe versus Ray, I, received a verdict in this very courtroom of X. So over time, you will have your own track record, your firm's own track record, your colleague's own track record, your, bar association's track record, and you'll be able to present that. But when you're new and you're trying to figure out what these things are worth, and when you're trying to show your client what things are worth, it's nice to be able to go on to Westlaw, go into the database and see what they have and see what the value are. Because sometimes, remember now, you have to manage your client's expectations. Your client may believe this isn't worth anything. We're not spending a dime. but you know as a lawyer that your client is exposed to, potentially millions of dollars of liability. And certainly you can have clients who think, it's me, I am worth more money than the earth has. And that's wonderful. But for the purposes of litigation where you have to value things, you're not going to be able to get an unlimited supply of money. So you have to have parameters, and those parameters are what your damages are. So that's something to keep in mind. And again, this is why I think it's very helpful when the mediators make each side do this statement at the beginning of the case, because when they do that statement at the beginning of the case, that is an opportunity for the other side to hear the case. I cannot tell you whether you're on the defense side or the plaintiff side. Sometimes you have to manage the expectations of your client. And when they hear that their case isn't the greatest case that has ever been tried, and they start to understand the weaknesses of their case, whether they're on the plaintiff side or the defense side, it helps them. It's almost like you're sort of, getting them used to the notion that what they thought trial would be and the kinds of results they thought they would have at trial are not realistic. And I'll give you another example. Many clients are usually people who watch a lot of law on TV. They know what Judge Judy would do. They know what all the TV judges would do, but they don't have a sense of what the real process is like, because on TV, everything is in a sound bite. And so they're not actually seeing it in real time. And this means that you will have to readjust their expectations. You will have to help them to see that there may be sound bites in a trial, but typically, a case requires thorough proof. It requires a number of witnesses. It is time consuming. It is fraught with things that you do not know will happen until they happen. It requires a lawyer who is fluid, able to, roll with a good day and roll with a bad day, because you could have a bad day and then have a great day. So these are all risks of how the outcome will come. Whereas on TV, hey, they have script writers, and none of you are ever going to have a script writer unless you write your own TV show. So what I want you to be aware of is that you are managing expectations, and you are helping people to see that the actual process is very different from how it can be encapsulated so that people can watch it for entertainment. So very important. Mediation is a great tool. Mediation will give you quality of life, because if your case resolves and you were planning to go on vacation with your family and now you can go. So mediation is your friend. You want to be good at it. This is a skill just like trying a case. It is a very valuable skill. We live in a time where there are people who are professional mediators. They take their law degree, and I do believe, that there are all kinds of mediators you find. There are lots of lay people who make great mediators, mostly because they're listening to what people really care about and what they want. But certainly the gold standard of being a professional mediator, the real gold standard, most of those people are lawyers or judges. And so you find that I'm seeing now that students come to law school with the goal of being a mediator or an arbitrator. Again, arbitration is starting to get a light shined on it, because arbitration favors the institution. And so if you're an institution, you want to have an arbitration, but arbitration sort of takes it out of the hands of the court. What's great about mediation is it's still ultimately in the hands of the court, but the parties have the opportunity to craft a solution within the bounds of the law that each party can walk away satisfied, maybe not thrilled and ecstatic, but certainly satisfied with the result. And I'm very excited to be a part of teaching mediation, because mediation is a skill that will always come up. You may not have a trial, but if your case progresses beyond the very first motions, ultimately you will see a mediation. And so for many people, they never get to try a case, but they have done many, many mediations. So I wish you luck. I think this is going to be a great opportunity, and it is another set of skills that you can lift and use, and they'll be in your toolbox for when you need them. Have a great day. Hi, this is Kim. I'm in the Moot